Welcome to the Greenspoon Martyr May 25, 2023 update webinar. My name is Robbie Birnbaum. I'm an attorney at the law firm of Greenspoon Martyr. I'm based in the Boca Raton, Florida office. With me, I've got David Schnobrick, who's a partner of mine, and David also works in the Boca Raton office. Greenspoon Martyr has offices nationwide, and we're proud to present this as a continuing webinar series that we do for our clients and also for interested parties to help keep the industry educated on industry developments. If you're not a member of our email list yet, please feel free to reply to that invite you got anytime or forward it over to me or to myself or to David, and we can get you added to the various email lists that we keep. Just as background before we get started, David's going to do the substance of this presentation today. I wanted to give you a little background on who you're hearing from today. Again, my name is Robbie Birnbaum. I run the Regulatory Compliance Department at Greenspoon Martyr. I've been with this firm since about 1998. Grew up in Wisconsin, graduated from undergrad and law school at Wisconsin, moved down to Florida, and been at the same firm ever since. Over the last couple decades, we built up a significant practice area in representing insurance companies, carriers, administrators, obligors, licensees, and helping a lot of sales agencies in their insurance sales agencies, in their lead generation techniques, the compliance that goes with those, the proactive relationships with the regulators that we've built up, and with a lot of licensing that the sales organizations and also the TPAs, the third-party administrators, need. We've had the privilege, and we continue to serve and provide guidance and representation to public companies involved in the industry, in the insurance industries. We've also done a lot with service contracts in that industry. We also do a lot with private companies and entrepreneurs. And if I could give you a history on the decades of call center experience that both David and I have been in, when it comes to offering insurance over the internet or over the phone, be it for personal lines, life, health related, or vehicle insurance or service contracts, it could fill a book. So we have a lot of depth, and we've been building this department quite a bit. And we're very proud to say that we have some very good relationships with both the state level and federal regulators who interact in this industry. The state level when it comes to the day-to-day regulation and consumer protection duties we have to deal with, the licensing, the policies, the like. And then the federal level when it gets to be a bigger issue on the enforcement side, when we have to play a more reactive role. We play those and we use those relationships to our clients' benefit so that we can make direct calls to the regulators, get issues handled, understand the issues. And then like today, we try to bring those issues to you and say, here's what's going on at this very specific state issue, and here's how we think you should be thinking about it. And we would like to bring it together sort of in this webinar, sort of as a family discussion. I think that's the concept I want to get across, that we've got this issue out there. How do we protect the industry, and how do we help protect each of you individually if you have had the issue of getting one of these notices we're going to talk about today. I noticed the current issue today came out because of a regulator in a certain state getting concerned about what's going on in the industry. I wanted to have this webinar because it's not just New Mexico. David and I have a lot of experience in dealing with other insurance regulators. We go to their industry conferences. We talk to their staff almost every day. I was on the call this morning with the California insurance regulator, and they're aware of the New Mexico issues, and they have concerns. So we've got about 3 clients who run very large sales organizations, and one set of common regulated carrier group, like a TPA, that is having a California issue now. And we just got off resolving 2 big California issues. So California is very aware of the same issues, so we're probably going to see something like that. Pennsylvania, we all know Pennsylvania and their Department of Insurance. They tend to get on airplanes and fly down to Florida a lot to visit 2 of the sales operations. We see them here in the call centers when we're doing our compliance reviews. And they're aware of this also. So I thought it would be good to have this webinar to give you some education. Just on background, to finish up on background, David, who's going to be presenting on this, David Schnobrick, my partner. David has worked with us for a number of years, quite a few years now, more than I think 5 or 8 years. And he's been deeply involved in these insurance issues. David graduated summa cum laude, which I know embarrasses him a little bit, but that means top in his class from law school. So we got a real smart one here, and we're really proud of that. But he deals a lot with licensing and proactive issues. One other concern that why David's going to present on this is because of NIPR, NIPR, the registration system. we're very concerned about how this New Mexico issue is going to be viewed by the other states and what the obligations are of companies that receive this and companies that didn't receive it is in the NIPR system as far as disclosure and the follow-ups you're going to get. So we're going to talk through that a little bit also. So that's the background. I'm welcoming you all to the webinar. We're really proud to present this. If you're not on the email list yet, please get on the email list because we do these about, I don't want to say once a week, but I try to do it once or twice a month on different technical issues. The next webinar, so you're aware, is going to be more focused on lead generation issues that are coming up in the insurance space. If you want to know, so I'll give you a hint because I want to put this out there before I turn it over to David. Specifically, the Federal Communications Commission. Remember I talked about state level and federal level, different issues we deal with? The Federal Communications Commission has a proposal out there, a notice of proposed rulemaking related to essentially, and I won't go into a lot of detail, but related into what's called multi-vertical leads. So when one lead generator, one carrier, one company out there generates insurance-related leads, the regulators at the federal level are getting concerned about how many recipients of those can use those leads to dial a customer, a potential buyer and insured back on the phone. So we're looking at the restrictions that they're proposing on multi-vertical leads, co-registration leads, and similar online generated leads that are translating into telephone calls by licensed insurance agents. So that's the next webinar. I'll probably do that in a couple weeks. If you're not on the email list, please get on it so we can send you the update and the summary on that. With that said, I'm going to turn it over to David Schnobrick, who is in our regulatory compliance department. I'll let him start at slide 1, introduce himself, and then go through the presentation. Following the presentation, you'll see emails, contact info. If you have questions, please feel free to send them in. We have, we look forward to filling our Memorial Day weekend with helping you guys out. All right, anyway, take it away, David, and thank you for the time. Please go ahead.
You've got it, Robbie. Thanks for that introduction. As Robbie said, my name is David Schnobrick, and I have worked the majority of my career here, at least in part, sometimes in significant part, in various aspects of the insurance industry. We've done large acquisitions, Form A, they call it Form A acquisitions for large insurance carriers, and we've done national insurance administrators and probably hundreds of insurance agencies, really big ones to really small ones. So it's no kidding that we are intimately familiar with these types of actions. We know where they come from, we know what they mean, but most importantly, we know oftentimes at least how best to resolve them and the kinds of ramifications and repercussions that can happen both short-term and long-term. So it's important throughout the process, literally from right now, through the end of it, through its resolution, to try as best as possible to mitigate the negative repercussions that can happen. Robbie mentioned NIPR. We'll be talking about that more later in the presentation. But if you do it right starting now, you can kind of minimize the issues that you have to deal with throughout the process. And so when you get to the end, it's easier to mitigate what could otherwise be problematic at best. So those are some of the takeaways I'm hoping that you'll come away with by the end of this. I will try at the end of this to also leave time for Q&A, but I want to be respectful of time, but I'll give you as much time as is necessary to answer any questions. There is a Q&A section of the taskbar. If you want to enter any questions, we'll try to get to those as well. If for some reason we can't get to them all, we will still respond to them via email, just we'll do it separately after the webinar. As Robbie mentioned, our contact information, emails, direct telephone numbers is at the end. So if you don't have it already, you can screenshot it when we get there. So one housekeeping item before we go too far. It's important to note that this isn't legal advice. For some of the people on this webinar that are already clients of the firm, you probably already got some legal advice related to this if you're one of the listed respondents in the notice. If not, this is intended to be more informational, okay? It's going to educate you. Hopefully you will leave more educated on this matter than when you came in. And I use, I call it generalities, and that's what we're going to cover is generalities, because there are now almost 100 different entities and individuals on this webinar. So it's not possible to address every specific circumstance. And that's important to know because everybody's circumstances are different. Very unlikely that there'd be more than one or two people with the same situation here. So I'll be general in terms of how I cover the subject matter of this webinar. But in any event, with that out of the way, let's get into the start of this thing. So what you're looking at now is something that at least the people who are listed as respondents in Appendix A to this notice should have received. I am aware of at least one person who's on this list that didn't receive the notice. Now that's important because if you are a respondent and you didn't get this, you need to figure out why that is. And there are only a few reasons why that could be, but you need to figure out why you didn't receive it if you didn't receive it. And for example, and Robbie and I deal with this all the time, if you have an old email address or an outdated physical address in the New Mexico OSI's database, and you'll just hear me call the Office of the Superintendent of Insurance, you'll just hear me call them OSI rather than say it every single time. If your information is outdated in their database and they send it to that old address, they're going to assume that you got it. And that, I'll tell you later, is an independent violation of the insurance code if they can't get a hold of you. So trust me when I tell you, if you're out there shaking your head when I say that, don't shake your head. It happens all the time. And we deal with a number of administrative actions every year where the genesis of the problem was that one simple mistake. So if you take nothing else away from this webinar, at least make sure that your information with every Department of Insurance in which you're doing business is accurate. So that you don't miss receiving something like this because it's extremely important. So in any event, what this is a notice of contemplated action. That is exactly what it sounds like it is. It is an administrative action recommended by the bureau chief of the Producer Licensing Bureau to the superintendent. In layman's terms, all that means is the bureau chief said, hey, listen, we think you did something wrong. We're going to fine you something for it. And we need you to let us know whether you want to do anything about that in the next 30 days. Now, here's something that's important, and I'll explain this more in just a few minutes. Don't ignore it. Whatever you do, don't ignore it. If you do ignore it, on the 31st day from the date that this was filed, which is the 15th, they will begin the process of revoking your license in the state of New Mexico. And I don't mean they will think about it. I mean, they will actually do it, and they will do it quickly. And the reason I know that is not just because that's what it says in the notice of contemplated action, but because that's what they did in 2022 as well. They will, and I think if memory serves, there were approximately 28 of that 100 people that just didn't respond at all. And so on the 35th day, those folks received an order of revocation. And there are some administrative methods of fighting at that point, but that is really not the right time to be getting involved in this. So whatever you do, don't ignore this. Actually pay attention to it, whether it's something that we're helping you with or something that you're just handling yourself or somebody else is handling it. Make sure it gets handled before that 30 days is up. It is important to note that, and I've spoken with the OSI about this. In fact, I've spoken with the prosecuting attorney who's handling this docket. The New Mexico OSI considers this to be an administrative action right now. That's important for NIPR that we're going to talk about a little bit later. I don't know that I necessarily agree with that 100%. Or at least I can see defenses to that. But at this point, what I'll tell you is they consider it to be an administrative action already. So they cite to the statutes in here. I'm not going to cover that stuff today. But the fact of the matter is that as far as they're concerned, this is an administrative action. That's important for NIPR's sake. And we're not going to argue about that right now because there's too many other substantive things we want to deal with here. So the way they do this and the way I'll compare with 2022's notice in a moment, but the way they did this time in 2023, and it's a good thing. In fact, let me go to the next slide. The 2022 notice, which you'll see on your screen right now, is, and it looks like it got cut off a little bit, but in any event, yeah. Okay, in any case, they did it differently in 2022, and here's what they did. In 2023, the Bureau's producer licensing chief basically said, hey, superintendent, I have this 100 people here that I think are these 100 entities. I think they've done something wrong. I'm going to recommend this following action to you. Well, in 2022, they did it differently. In 2022, they had the superintendent of the insurance department directly on his own motion, without any involvement from his staff. He, on his own motion, sent out this notice of contemplated action. Now, that's important procedurally for a couple of different reasons. And one of them is going to prove to be hopefully a silver lining for the people that were named this year. And here's why. If you look at the bottom of this section here, you'll see that the superintendent, because he brought the notice of contemplated action on his own motion, he was able to include an embedded order in the notice of contemplated action. So the terms of the order, what that means, the terms of the order were already written into the notice. Now, we don't have that here in 2023, and that's a good thing, because what it does, theoretically, is it gives us the opportunity to still negotiate the terms of the resolving document, which is likely to be a stipulation, or we can modify the language of how it reads. That's very important when it comes to what we're going to say about NIPR a couple slides from now. But what's important is that that although there's never good to be named in a notice like this, the folks who got named in 2022 had it a little bit harder. So we've got maybe some procedural differences here that we can hopefully take advantage of. So now what you have to decide is how you're going to proceed. And everybody that's on this call, and there's 100 people now, everybody that's on this webinar has the potential, at least, of handling this in a different way. There are too many variables and too many circumstances for me to try and cover the different things. So if you have a specific situation, that would be something that we would need to talk about. But the first option is to challenge the notice of contemplated action formally. I listed the administrative code there, 13159, that lists the administrative requirements and how you do that. It's very formalistic, it's very ritualistic, and there are a lot of elements to a petition for hearing that's loosely based generally on the Administrative Procedures Act, modified a little bit by Mexico. And so you have to draft a petition, you have to explain why you think that they're wrong, and then you petition them for a hearing. And I will tell you now, this is an appropriate resolution method under a minority of circumstances. Generally speaking, there are some extremely legitimate cases when I would say it is the appropriate resolution method, but they are minimal. There are only a few. For example, if you said to me, I have faithfully affiliated all my agents every single year, I would say we should probably contest this. I would challenge the notice. We may even get removed from the docket before that if we were able to show that to the satisfaction of the attorneys at the OSI, but maybe not. More importantly, there are a lot of other circumstances where that might be the case, but in the grand scope of things, for the people who are listed here, I think it is safe to say that this is probably not the best way to handle it, but there are absolutely exceptions to that rule. So here's what happens if you do challenge it. And for those on this call where you think that's an appropriate method, please let us know that, or at least make sure that you are aware of what will happen, because the first thing that will happen is you'll have to file that petition. If it is not satisfactory and doesn't follow the rules, it will be found deficient and the superintendent will not accept it. If you draft it correctly and it is found to be non-deficient, the superintendent of the OSI will appoint a hearing officer. It's important to note that that hearing officer will very likely, or at least possibly, be an employee of the OSI, might even be another examiner of some kind. but it will be someone experienced in this subject matter. That person, once appointed, will set the matter for hearing. And at that time, maybe a day or two later, you'll get the document that you're seeing on your screen right now, which is their disclosure of witnesses and exhibits. Now, the reason that's important, and you'll get it very quickly, is because they want you to know the evidence against you and that will be presented at the hearing. And it's always mostly the same things, depending on the specifics of your situation. But two things that are always going to be on it. Number one, you're going to get a witness who's going to be the OSI compliance supervisor. Vanessa De Jesus is actually a senior compliance supervisor at the OSI now. She has been a witness in these, I don't even know how many times, but she's very good at it. And her only job is to provide foundational testimony about what the documents are that are going to be presented against you. And those are going to be really two, maybe three things. It's going to be your licensing record. It's going to show everything you've ever done on your license, at least that the New Mexico OSI has records of. It'll be what you've paid, when you've paid it, when you've renewed. Most importantly, it's going to tell how many times you've paid for affiliations of agents. And so if there are no affiliations of agents there, and sometimes there are, maybe once in 2018, once in 2020, whatever it is. But if there are none, and you have no affiliations, and you have no affiliations, and you've never done this, you'll see on the next slide, it may not be a good time to fight this issue. The other two things they're going to present are going to be letters. They call them deficiency letters. Theoretically, everyone on this list of respondents, all 100, theoretically should have received one or two, probably two, notices of deficiency. And what that is the OSI sending a letter that basically says, hey, we notice you don't have any affiliations of record on your license. That's a violation of the insurance code. You should fix that. And they'll send that letter twice. And if that letter, either you don't receive it, and we talked about that at the beginning, or you don't do anything, they will send out your name on a notice of contemplated action. But they're going to tell you, basically, we sent two letters and they ignored us. And that's why we're here today, Mr. and Mrs. Hearing Officer, because we tried to do this the nice way and they didn't listen to us, or they just ignored us completely. And so there may be other documents after that, but that's the some extent of what they really need to present. And so if you haven't received those letters, for example, that's an important piece of information, but we need to figure out why you didn't get them. And so that's part of what happens if we evaluate this for hearing. The other path for resolution is to negotiate one, we'll say amicably, but at least it's non-adversarial compared to a formal hearing before a hearing officer. There are a few things that will happen. The first two on this list, the first two bullet points, accept the administrative fine of $500 and affiliate the agents that you need to affiliate and pay the fees you need to pay. Those are non-negotiable. If you don't do those and you say, I'm not doing that, they'll say, no problem, let's get this thing set for hearing right away. Those are conditions precedent to settlement. If you don't do those, they won't settle and they won't resolve it amicably. And they will probably revoke your license if you don't do those two things. But the important part is that if you've never affiliated a license or affiliated a licensed agent to the agency's license, there are specific forms, methods, and logistics as to how that's done. They have a form that they have on the department's website where you can go and look at it. You can pull it down. It's not terribly complicated, but it's burdensome. It's especially if you have a lot of agents, it takes time. So you have to be aware of that if you're looking at deadlines, which at this point they do exist. So those two things are going to be non-negotiable. The next few bullet points are important because this is where you negotiate the non-monetary terms of the resolving stipulation. And more importantly, you determine the language that will appear in it and the resolving order that'll issue after the stipulation is agreed between you and the OSI. So the reason that's important, I'm involved in this process right now, and I think Robbie and I are involved in this with multiple clients at this point, where we're trying to hammer out that language. I was on the phone with the OSI attorneys last week, trying to see if I could get a template of what that resolving stipulation would look like before this webinar. And I wasn't able to get it from them yet. So we're still working on what that's going to look like. But as I said, that's the silver lining for 2023, is that we don't have to worry about the fact that the order has already been written. That would lock us into a path where we wouldn't necessarily want to be. So once that happens and the stipulation has been drafted, and there's going to be changes and differences in that stipulation based on the specific circumstances of the entity for which we're resolving the docket. So it will be different between clients. It will be different between entities based on the circumstances at play. One of the things that's important, and I'll cover this on the next slide as well, sometimes in the process of being scrutinized for affiliation issues, there may be other issues that arise. A lapse in licensing, a failure to pay something, a designated responsible license producer has been lost an appointment or an appointment to a specific line of insurance, and so the agency shouldn't have been operating. There's an endless list of those peripheral issues that can come up. It's very important to know what those are if you can, and if you don't, it's possible to get blindsided with those. So it's important that you take a look at your licenses in the state and make sure they're in order, because they'll bring them up in the process of resolving this issue. They'll want to bring up other issues too. So that's why it's important to scrutinize the terms of the STIP for post-resolution considerations. And that's the next slide. But before I get to it, you see I have a bullet here for alternative options. I've gotten quite a few emails from people about this that wanted to get questions into me before the presentation started. One of them, and I'll cover this a little bit more detail in a minute, somebody asked me what would happen if they just said, hey, listen, I don't want to do business in New Mexico anymore. I'm just getting out of there. What happens if I just give up my license and I turn it in and I just say I'm not going to operate there anymore? That's an option. And there are other options like that. The problem is, in a lot of states, you will find that if you surrender a license in response to an administrative action, that you will find that the state in which you're surrendering that license will interpret it as a revocation for purposes of future licensure in that state. So it's a little trickier than it would ultimately seem. So you have to be careful doing that. It is possible that they would just say, okay, if you want to turn in your license, we'll take you off the docket. Have a nice day. Pay, they're still going to make you pay your administrative fine, most likely. But if you get out of the state, you probably won't have to affiliate any agents. So you'll skip a step. There are other alternative options like that, but be careful in selecting them, that you know the ramifications of what that means. So how do you figure out what to do? And here's a few questions, and there's more than this. This is certainly not a non-existent list of questions. But here are some good ones, important ones, in fact, and the first one is probably the most important one. Is the OSI wrong? Do they have it wrong? Is your affiliation issue actually not what they say it is? More importantly, I guess the question is, are they right? And so you'll know if they're right. If you have never affiliated an agent to the entity license, or you haven't done it in a while, that's going to be something that they know, because they don't just pick 100 people and say, let's check and see if they have affiliation issues. They go through an audit of, to get 100, I bet they go through 500 to get 100 where they find an issue. And so you'll probably find that you haven't done the affiliation requirement. What's interesting, and this has been raised, but it's never been conclusively resolved. In order to get a license in New Mexico, one of the requirements is that when you submit your application, you also submit an application to affiliate licensed agents to your entity license before it's granted. So theoretically, a license should not have been granted to you if you didn't have an affiliated agent. The superintendent's office is supposed to verify that at the time they grant the license, that you have at least one affiliated agent. Now, that is not very likely anyways, not a dispositive issue that probably won't get you out of trouble, but it's worth noting, and it has been raised in the past. So as a theoretical defense to kind of throw up and say, here's something we're going to put in front of you, and say, why didn't you, let us know that we had a deficiency at the time we licensed? That's probably not going to resolve the issue in your favor, but it's interesting to note. Number 3 on this list, are there other outstanding issues that might come to light? I spoke about that briefly. You need to know other things. And as you read down 3, 4, and 5 kind of ties in. Do you have other issues in other states that you've resolved? Have you regulatory issues that you had in another state that might factor into this one? And the next slide is going to explain why these are important, because this is stuff that's going to get reported to NIPR. The National Association of Insurance Commissioners is going to be aware of it, and it's going to be out there, and you're going to get follow-up questions about this issue. So it's important to know what's going on, not just in the state of New Mexico, but in other states. Robbie mentioned Pennsylvania earlier. There are other Pennsylvanias out there. California's a huge, I wouldn't say aggressive, but they have got a lot of regulatory actions out there right now. But number 4 is the interesting one. I have spoken to people who say they didn't get the notices of deficiency, but then they look and find that they were in their email all along, and they maybe just didn't recognize them for what they were. A lot of people are not familiar with the affiliation requirement. It's not a typical requirement in most states, but there are a handful where it is a requirement. So it's important to know, once this issue goes into NIPR, it's important to know that you are compliant in other states who are going to see the report of this action. So let's get to the next slide. This is kind of how you want to think about what happens after it's said and done, because it's not just a matter of resolving it. It doesn't matter how it's resolved, irrespective of whether it is resolved by amicable means, by negotiated resolution, or by you won at a contested hearing. It's still going to have to get reported in NIPR. It's just a matter of what it looks like at that point. So the important part also is that, well, at the beginning, I said, I don't know if I agree 100% about whether we consider this to be an administrative action at this point, whether I have arguments counter to that or not. Once it gets to this stage, and it's going to get to this stage for everybody that's a respondent who responds, once an administrative fine has been assessed, once there is a resolving stipulation, and once there's an order issued by the superintendent's office, there's no getting around that this is an administrative action. It's got to get reported to NIPR. All the resolving documents, the charging documents, they got to get uploaded to the reporting of actions warehouse in NIPR. Now, the interesting part is, although all that is true, you have an opportunity, and it's not mandatory, but it's certainly recommended. You have the opportunity to include with your submission to NIPR an explanatory letter. This is very important because it's essentially your side of the story. It's not a blanket, write whatever you want letter. It is a letter that says, here's what I think happened. My compliance analyst left the company, and, somebody, whatever it might be, whatever the situation is, we kind of put some color on it, and we can say, listen, I'm not a bad actor. This wasn't something I blatantly decided I was going to just ignore this regulatory requirement. I have reasons for what happened. Now, what's important is, as I said at the beginning of this, the process starts now, and the explanatory letter that you'll want to have created and drafted must be consistent with what is in the stipulation and what's in the resolving order. You can't contradict what's in there, because if you do, you're going to have a problem with the OSI. They're going to say, what's this? Maybe other states as well. So it has to be consistent, but that is why it's important that you very carefully negotiate the terms of what appear in the stipulation and the order. Because if you can't put something in there that says, I don't admit or deny that I did anything wrong, you can't deny that you did anything wrong. If you admit that you violated the insurance code, your explanatory letter can't say, to this day, I protest that I didn't violate the insurance code. You can't do that. So that's why it is extremely important that right at the beginning of this thing, you get in front of what that language is going to look like at the end. Because as you'll see in number 2 and number 3 on this list, there will be subsequent state inquiries. North Carolina is famous for this. They will send a letter to you that says this will happen anytime after 30 days from the date that the stipulation and order are finalized. Not the date that they're uploaded into NIPR, but the date that they're finalized, because the OSI will upload them also. There's a different portal for them. They're going to get uploaded. They're going to report it. So you better report it. You've got 30 days in most states to do that from the date it's resolved. So these states, for example, North Carolina, very famous for it, will say, hey, we couldn't help but notice you had this action in New Mexico. Tell us what happened. And that's how North Carolina does it. Other states may say, as you'll see in number 3, where I say cascading DOI requests, other states might say, hey, you violated the insurance code, we think, in New Mexico. Hey, when you violate the insurance code in New Mexico, it's a violation of our insurance code too. And that's true in most states, believe it or not. If you violate the insurance code in one state, other states can interpret it to be a violation of their insurance code that you violated the other state's insurance code. So it can very quickly become a domino effect. I say cascading, domino effect, whatever analogy you want to use. If you get one and you don't handle the first one right, you're going to get more. Importantly, as I say in that first bullet point under number 3, this will have to be something that will need to be disclosed going forward. So for future licenses, if you're trying to get licensed in a new state, for renewal applications, you must disclose this. They will ask certain questions. Now, I will tell you that there are various ways of asking the question. Different states ask questions differently on renewal applications, which is where this mostly comes up. So you have to very carefully read the language. If it's not required to be disclosed, you don't need to disclose it. But most of the states will require it be disclosed. It's an administrative action. It's been resolved, but it's still an administrative action. So if you don't disclose it, somewhere along the way, they're going to find out. And it might not be until 3 years later. But at that point, they're going to say, listen, you didn't report it then. We found out about it. And if we want to, and this is true, they can revoke you just because of that fact. Anything that they could say, we have the right, and this is a very broad power of the insurance commissioner or the insurance superintendent or whoever leads the DOI in that state, broad power to say, if I could have denied you a license then or suspended your license then, I can do it now, retroactively. So it's important that you don't forget about this when your next renewal period comes up, because if you forget about it, you'll be reminded later. At some point in time, you will be reminded. So be very careful, make sure you don't forget it. Read those renewal questions very carefully in your next renewal cycle. Piggyback actions are what I was kind of referring to, where one state will say, you didn't do this requirement in that state, and we're going to cause that to be a, and they'll say similarly, they'll say it's, not a big deal. It was only a $500 fine, but we're going to assess a $500 fine. And then you've got another administrative action to report in NIPR. And that's how the snowball starts. And so you get one, and then you get a whole host after that. So it needs to be resolved as conclusively as possible, as early as possible, because otherwise this is something you're going to be dealing with for a little while. And it may be anyway, but it's easier if it's handled correctly at the front end, right at the beginning. Because if you just, and the last bullet point here, I really think it was 28 people who didn't respond in 2022 when the superintendent issued his notice of contemplated action at that point. Those 28 people, I don't know what happened. They didn't respond. They just went completely quiet, didn't do anything, and they got revoked as an effect. But the problem with that is, if you get revoked or even suspended in New Mexico, other states are going to do the same thing. And in fact, it's going to be a very, very ugly situation. Heaven forbid the state where you hold your resident license has a similar law on their books, and they say, well, you got revoked or suspended in New Mexico. We're going to revoke or suspend you here in your home state. Because if that happens, every license you have that's based on the reciprocity of your home state license is going to start to terminate as well. So that's why this is so important not to ignore or handle incorrectly, because if you do, it gets very messy, and trying to fix it later on is way harder than if we just would have addressed it kind of head on at the beginning. So that's important to know. But in any event, that's substantively all I wanted to cover here. I went a little longer than I wanted to. Forgive me for that. But I wanted to get this information across as much as possible. There are some questions that I will pull up now, and I'll try to get answered for you. Anybody that is, okay, okay, so here's a person that says, I have no intention of operating. I'm not going to divulge who they are. No intention of operating with my agency in New Mexico, so I never renewed the affiliation. I've got an individual license that needs to remain active. I'm appointed with a different agency there. If I don't pay this ridiculous fine, what happens to my agency in other states? Okay, and does this affect me being able to get appointed in other states under my agency in the future? I kind of did cover that. There is at least, now I don't know the specifics here, but based on just that situation, if you ignore this and don't pay it, I mean, I don't know if that's something where it's, I just want to blow this off, or I don't, you know, generally speaking, I don't see a way around this affecting other states. But if it is a personal license, depending on how you're, you know, if you were the principal of the agency or the DRLP of the agency, there could be tie-ins where there's going to be an effect to you in the future. So it's not worth taking that chance. It does, in fact. Now, interestingly, it says,
David, before you get to the next question, can you put up the next slide so that people have our email addresses so they can send in questions after the presentation also?
Yep.
That's great. Go ahead. Sorry.
Yeah, now one thing I didn't mention, and I think it is worth mentioning, is that oftentimes you have to disclose these kinds of things to the insurance carriers that you're contracted with to sell their products. Especially if you're trying to get appointed with a new carrier, they will oftentimes ask you about administrative actions that you either have pending or have resolved. And sometimes they will, and particularly now, there are a lot of gun-shy insurance carriers in this space. And so it's important to note that if you have a situation like this, posturing it correctly might be important for how you get appointed with insurance carriers going forward, not just renewal applications or future license applications. The next question is, if I'm a licensed agent in New Mexico, do I just need to name myself as an affiliate to my business license? It depends. If you are a licensed agent in New Mexico, the obligation really falls upon the business. So if the business is, if you are the only affiliated agent with the entity license, yeah, that's all you got to do. Affiliate yourself to the license, cost you $20 to do it, and you've done what you're supposed to do. You know, and I'll tell you this, it's always been my suspicion, I don't know this, it's always been my suspicion that they will look to see if you have any affiliated agents. And if you have one, just one, they may pass you over in favor of looking at other companies where they can definitively tell that there are no affiliated agents. It's not the way you should do it. That's not how you should do it. But if you have an affiliated agent, even if it's one, it's better than having none, because they can see none real quick. They don't know if you have more than one agent in your agency. They can tell if they look close enough, but in any event. So yes, the answer to that question is yes. Also question, can I complete the affiliation form and send it into the OSI to get back into compliance? Yes, that's exactly what you should do. Now, don't just do it randomly. You have to do it in connection with resolving this issue. So you'll need to, you know, I don't know if this person who submitted this question is represented or is not represented, or I don't recognize the name, so I don't think it's a client of our firm, but it could be. And so if this person was to complete the affiliation form and just send it in, that would resolve the affiliation deficiency, but it would not resolve this docket. Okay, the docket would still be outstanding. You still got to contact the attorney. You still got to resolve this issue. Still got to pay the $500, which coincidentally is the next question that was asked. Do I still have to pay the $500? And the answer to that question is going to be almost 100% yes. There are a few more questions, and I'm gonna continue to go through this. So if you need to drop off, I understand. Our contact information is there. If you have questions, you can reach out to us directly, but I'll stay as long as people are submitting questions and try to get them answered. The next question is, I applied for my licensing and affiliation in June 2022. My agency sold in December of 2022. The new owner holds all non-resident licensing, and the LLC that was sold is gone. Less than a year since applying. With the sale, would not have thought anything was needed. Have to check if correspondence from OSI was received. Unsure if there's any leverage in this situation, and I can see why I am unsure as well. There's not enough details there for me to know for sure, but at the end of the day, it depends on whether the individual license is affiliated with a licensed agency. Now, as I said at the beginning, unless you're a sole proprietor, and that's a different situation completely, if you are an agency or an agency owner, the onus is on the agency to affiliate the agents. The agents might not be affiliated, but it is still entirely possible that the agency can get in trouble and the agent might not. But the onus is on the agency and not the agent. So you have to be aware of that. So if I pay the fine, surrender my license, I'll be removed from the docket and everything will be fine is another question. Not necessarily. That will take care of some of it, but as I said, number one, the surrender could very well be perceived as a revocation in the state of New Mexico, which is not a big deal. If you'd say, I'm never going to go to New Mexico ever again, I'll never do business there. If that's the case, then you will never have to deal with New Mexico saying, well, your license was surrendered in response to an administrative action. And so we consider that a revocation. Now, the problem is if you're going to stay licensed in other states, you still have to report it. You still have to pay the $500 fine, and you still have to get whatever resolving document they're going to use out of the way. Now, if I believe it is possible, and this is something I don't have confirmation of yet, I believe that as a method of resolution, it is likely that the OSI will say, if you come to them and say, I will surrender my license and pay the $500 fine, they may say, no problem, we will remove you from the docket. And they will still make you sign whatever resolving document that there is. You will still have to report that to NIPR. So some of this stuff is going to survive unless you're getting out of the insurance industry altogether. And that's a different situation, probably not true of most people here. But yes, you'll still have to do some things, but I have a feeling, and I'm seeking confirmation on this, that it will get you taken off the docket. So you won't have to deal with it anymore as long as you follow whatever rules they're going to put in place to resolve it formally. The notice we received has more than 100 agencies and companies listed. It was about 500 or more. I'm not sure what that means, if that means that there were 500 or more agencies, but that is not unusual. There are probably separate dockets, and that's a good point. So what this person is saying,
what that's referring to is I got that from another client as well. There were multiple notices as far as we can send out. There were like over 1,000 different, I don't want to say people, groups on each one. So there were multiple. We will only send out one link, which is an example, but there were others.
Yeah. Yeah, I think they max out their docket at 100 per notice, but yeah, that's right. The next one, Robbie, I might let you handle this one. This one says, do we need VSC and home warranty licensing in New Mexico?
No, that's a different topic. I'll take that offline with them. No problem.
Okay.
There's about 3 left on here you go through.
Okay. Same person from a different question asked if we got a different notice than what this webinar is about. I don't know what you received, but if it was a notice of contemplated action from the New Mexico Office of the Superintendent of Insurance, you may have received one of the different notices. It may be a different docket, but it should be a relatively substantially similar document. If you got something different, that might be something we should address offline as well. The next person says that the $500 fine seems high. I've requested a hearing to ask the OSI to reduce the administrative fee from 500 to the minimum 100. Have you seen them reduce this fine before? The answer to that question is yes. I have seen them reduce this fine before for good cause. You need to have a good reason why you're asking that. If you just have never ever, for example, if you've registered your affiliates, you've affiliated your agencies or your agents every year, and for whatever reason, it dropped off the radar this year and it just simply slipped through the cracks, they might be amenable to that, but they're not going to do it unless you have a good reason. I mean, It's unusual, let's put it that way, because in the big scope of things, $500 for an administrative action, administrative fine is not that high. I mean, I know it's a good amount of money, but in this context, we've seen substantially higher numbers than that. And since we know that the maximum they can charge in this context is $500 and the minimum that they can charge is $100, they're not going to begrudge you the question. Just make sure that you give them a good reason, because what they're going to say when they talk about that behind the scenes, the attorney and the director or the bureau chief, what they're going to say is, what reason do we have to do a downward departure from our statutory normal of $500? They're going to say, they give us a good reason to say why we do that, because otherwise we're not going to do it, because everybody would ask us to do it. If we do it for no reason for this one, we're going to have to do it for no reason all the time, because other people are going to ask it. And I assume other people do ask that question. But if you can give them a good reason, they're not going to begrudge you asking the question. If you give them a good reason, they may very well do it. So the answer to that question is sure, I have seen that happen. Next question is, what if we do not have a license in New Mexico because of an exclusion based on an established business relationship? I have a feeling that's a question related to a separate subject as well. That could be a telemarketing related question or something like that. I don't know. But if that person wants to clarify or take it, send me an email with more details. I'll see if I can answer that one, but that might not be related to the OSI. Another individual asked if we have renewal applications in other states currently pending. Do we currently have to disclose the administrative action on those renewal applications prior to our resolution with OSI?
That, I don't know if you know the answer to that, but that's a big deal right now. So that's a good question.
It's a very good question. As a foundational answer, when you submit an application to a Department of Insurance, OSI is no exception, you are under a continuing duty, a continuing obligation, where if material information in your application changes, you are under an affirmative obligation to tell them about it. Now, right now, I will tell you that prior to resolving it with the OSI, as I said at the beginning, I think there are arguments why you wouldn't have to report it now. However, I think that if you have renewal applications in other states, it is going to be the expectation of those departments of insurance that you report it. And so at the very least, you're going to have to report it when this is resolved, and we have no longer than 30 days. At this point, we probably have 15, 20 days to get this resolved completely. And so the book answer and the truth on this answer, the book answer is I could make arguments why you wouldn't have to, but the truth of the matter is I wouldn't take a chance about it, because some people, as a method of more the, in an abundance of caution mentality, will in fact report it. And I don't think that's the wrong call. I don't, Robbie, you feel otherwise about that?
I think that this administrative, you notice it says notice of contemplated action, but it's sitting as an admin action in the Department of Insurance. I think that most states would want this notified to them through NIPR. And I know for a fact that most of our clients would say, no way are we putting this in until we get it resolved, because we're going to get deluges of follow-up inquiries from other states. It's like an automatic, you throw the ball against the wall and 10 more come back and hit you in the head. I think you are supposed to report it, but I don't think companies are going to.
Yeah, I think that's right.
Yeah. Why don't we finish up with 2 more questions, because I know we're coming up on time. Okay. And then I want to remind everyone, we value your questions. I wanted the slide up. You have both David and my emails and contact info in front of you. Those are our direct lines. As you can tell, David is the expert on this nationwide. So we would encourage you to call him later today or tomorrow, or just email him with your questions also. Okay. But go ahead, David.
Okay, so two last questions then, and there are more questions here, and if I will try to respond to those offline, at least via email, so that the people who've submitted questions will at least get answers. The first question is, if we have a valid New Mexico license and also a New Mexico license for our agency, we're not sure what we did wrong. It's a legitimate question. The fact of the matter is, in my opinion, and I've had this conversation with people in the OSI, the superintendent's office is supposed to make sure you have an agent affiliated with your license before they grant it. but they habitually don't do that. So the only thing you did wrong is not, and this is part of the licensing process, so, but a lot of people, as you can tell, don't do it. You are supposed to have at least one agent who is going to be representing the agency as a selling licensed insurance agent affiliated with the entity's license. So you might have a licensed agent and you've got a licensed agency, but they have to be connected. If they're not affiliated in New Mexico's database, that's the mistake. It's not typical of all states, but in this case, that's what you did wrong. And I will only say wrong in the context of the fact that it is a regulatory requirement, so you're supposed to do it, but that's the answer. So last question is, where did we get the affiliation form? If you Google, I have it. If you want me to email it to you, I'm happy to do that. But if you Google, just make sure you're getting the right one because there are different ones. If you Google New Mexico OSI affiliation form, you're going to get answers that are going to be a few different forms because there's a form for affiliations, there's a form for removing affiliates, and there's forms that do different things related to the affiliations that you have. So if
Right.
whoever wrote that question, if you want to email me, I'll send it to you so you know you got the right one. Otherwise, you can't find it online if you Google the right search term. Just make sure it's the right one. So I guess that's all the questions we're going to do for now. Our information is on your screen. Anybody that submitted a question, I'll get to answering them. But otherwise, I just want to thank everybody for coming and wish everybody a happy Memorial Day weekend.
David, that was a great presentation. Thank you so much for doing that. And once again, for questions or answers, you've got the information on the screen. Contact david.schnobreck@gmlaw.com. Please make sure you're on our email list because as I said, our next webinar will be on this multi-vertical lead issue, which is very concerning and very timely for this industry. With that, thank you all. Have a very safe and happy Memorial Day weekend. Best wishes to all. That concludes the presentation today. Thank you for attending.